Hello, everybody. I'm Mónica Vargas from the Transnational Institute, and I welcome you to this webinar. We are sorry to be a little bit late. I will be facilitating the webinar. And first of all, I would like to remind you that there will be interpretation to Spanish, English, and German. So you need to make sure that you activate the globe and you select your language in the below part of your screen, of your Zoom screen. Este webinario será interpretado hacia el castellano, el inglés y el alemán. Por favor, seleccionen en la parte de abajo de su pantalla el icono de globo y ahí pueden seleccionar su lengua, ¿no? And we thank a lot in advance to our interpreters, also to the team that has put a great effort in the preparation of the webinar, and as well, of course, to our panelists that are joining us today. We'll be recording this webinar and it will be available at thewaterchannel.tv. And if people have objections to the recording, so please just make sure that you put your cameras off, and you can also change your name as participant to an anonymous name. And yeah, this webinar is organized at the occasion of the Global Anti-Chevron Day, and it will be on international arbitration and corporate impunity, lessons from the cases on Chevron and RWE. And it has been co-organized by the Union of those affected by Chevron Texaco in Ecuador, UDAPT, by the Water Channel, by SOMO, the Seattle to Brussels Network, FDCL, CETIM, the Association of Ethical Shareholders from Germany, the Kommunische Büro for München in Germany, the Global Campaign to Reclaim People's Sovereignty, Dismantle Corporate Power and Stop Impunity, and the Transnational Institute. Also, on the occasion of this 21st May Anti-Chevron Day, the questions we're going to address are, for example, the functioning of the Investor-State Dispute Settlement System, ISDS, especially regarding the cases of Chevron in Ecuador and RWE in the Netherlands. The case concerning Chevron's oil pollution in the Amazon raises a question on how an arbitral award can order to the state of Ecuador to impede the enforcement of the sentence of its own judicial system, as well as how this award could be set aside. And in the case of the energy company RWE in the Netherlands, the questions are around the legality of the ISDS system according to European laws in the context of the Energy Charter Treaty. So we're going to open the space now to our panelists. We have the privilege to welcome Pablo Fajardo. Pablo Fajardo is a lawyer of the UDAPT, and he coordinates the litigation in the Chevron case in Ecuador and other countries. He actively participates in the global campaign as well as in the process towards the UN binding treaty at the United Nations, and he's part of an international panel to define the oil spills as a crime against humanity. And in addition to the Chevron case, he has participated in other litigations, especially in a lawsuit against the Ecuadorian state to end routine gas flaring, as well as in climate litigation with the Guarani people. So we'll give to Pablo 7 minutes to share with us the arbitration between Chevron and the Ecuadorian state, 7 minutes, and perhaps we'll have time, I'm not sure, to get one question, clarification question. So Pablo, adelante, ¿quieres prender la cámara?
Bueno, muchas gracias, buenos días. No sé si me permiten encender mi cámara, si es posible, si no, sigo nomás con el audio. Bueno, en todo caso quería ratificar, mi nombre es Pablo Fajardo, vivo en la Amazonía Norte del Ecuador y obviamente aquí trabajamos con la UDAPT desde hace 27 años en ese proceso para buscar acceso a la justicia. Ya sobre el problema del daño en sí, perdón, Mónica.
Perdón, si quieres activar tu cámara, Pablo, es el iconito que está debajo del, ¿sabes? Al lado del micrófono, para que te podamos ver. Bueno, no te preocupes, Pablo, adelante. Please go ahead, Pablo. I will share another screen. Adelante, Pablo, gracias.
Ok, bueno, Nuevamente, gracias. Decía que el proceso contra Chevron es un proceso que revela muchísimo esa impunidad corporativa transnacional y global. No voy a explicar más el daño porque lo hará Humberto en la ponencia siguiente, pero sí un poco cómo el sistema de arbitraje internacional se convierte en uno de los grandes eslabones para garantizar la impunidad a las transnacionales. Luego también, desde nuestro punto de vista, cómo el sistema judicial doméstico holandés es también parte de ese sistema de impunidad de las transnacionales. Noten ustedes, en el caso Chevron, una vez que probamos hasta la saciedad el daño ambiental, el crimen ambiental cometido por Chevron, y que en 4 instancias, 4 sentencias judiciales han ratificado la condena en contra de la empresa Chevron Corporation, la última de la Corte Constitucional de Ecuador del 2018, cuya decisión es inapelable, esa decisión no se la puede revertir, está en firme y solamente falta la parte de ejecución de la sentencia. Entonces, esa sentencia está vigente y como UDAPT seguimos buscando mecanismos para ejecutarla. Pero ¿cuál es el problema? Que esa decisión de la Corte ecuatoriana, la final, fue en junio del 2018. En agosto del 2018, un panel de arbitrajes privado emitió un laudo arbitral, en cuyo laudo, de una forma bastante alejada del derecho, se dice y se ordena al Estado ecuatoriano que el Estado anule la sentencia del caso Laguardia, es decir, el caso que lleva la UDAPT adelante. Dice también que el Estado impida que nosotros, los afectados, podamos ejecutar la sentencia en otros países fuera de Ecuador. Son decisiones que están al margen de la Constitución. Esas decisiones violan los derechos humanos de más de 30.000 indígenas y campesinos que por más de 27 años estamos y seguimos luchando en esa búsqueda de acceso a la justicia. Ocurre que luego Ecuador plantea un recurso de nulidad ante el sistema judicial doméstico holandés. Hay que explicar esta parte un poquito porque es importante. El sistema de arbitraje ISDS no permite apelaciones. No hay un recurso superior. Solo se puede plantear un recurso que llamamos derecho horizontal, es decir, paralelo, ¿sí? En este caso, ante el sistema judicial holandés, porque ahí está la sede, la matriz del sistema de arbitraje bajo la regla ancestral. Entonces, se plantea esa acción y ahí viene un poco otro gran eslabón del problema, que esos procesos de nulidad que plantean generalmente los estados, los resuelven jueces que no están preparados de forma técnica para ese tipo de casos. Son jueces comunes del sistema judicial interno holandés. Es decir, un juez que generalmente tramita acciones de familia, de laborales o de trabajo, o algún tipo de delitos, ¿sí? Que no están preparados. No hay una escuela de preparación para estos jueces que conozcan estos casos de derechos o de inversiones de otros estados. Entonces, un juez doméstico termina juzgando a un estado. Pero hay otros elementos mucho más graves todavía del sistema. Es que hay ese secretismo, esa confidencialidad, que no se permite el ingreso, la participación de la gente afectada. Entonces, en un proceso, juzgan o pretenden juzgar nuestros derechos sin que la gente afectada tenga el derecho a la legítima defensa, lo cual ya es otra violación a los derechos humanos. Ni siquiera tenemos acceso a la información, o sea, no conocemos qué pasa allí. En teoría, se supone que el Estado debería informar a sus ciudadanos lo que ocurre en ese proceso judicial, pero eso jamás ocurre. Hay que decir que el gobierno ecuatoriano, en los últimos 4 años, el que está saliendo, el señor Lenín Moreno, se ha puesto de servicio del lado de Chevron y ha hecho una defensa pésima en el sistema doméstico holandés para nulidad del laudo arbitral. y es más, jamás ha informado ni va a informar, porque ya se va, sobre ese proceso a la gente afectada de la Amazonía ecuatoriana. Entonces hay una parte mucho más grave, que es esa perpetuidad de la violación de los derechos humanos de más de 30.000 indígenas y campesinos de la Amazonía ecuatoriana. Nosotros no nos conceden el derecho de participar. Entonces, ¿qué ocurre? Que en el fondo el sistema de justicia doméstico holandés se convierte en ese último eslabón que garantiza impunidad a las transnacionales, que dejan indefensión a los pueblos víctimas de crímenes corporativos, que terminan sometiendo, juzgando a un Estado, y es más, un sistema de justicia externo juzga a otro sistema de justicia de otro Estado. O sea, se rompe por completo la soberanía, la independencia de los Estados. O sea, es un sistema realmente que sí da mucha indignación el saber cómo los pueblos nos quedamos o nos pretenden dejar sin ese acceso a la justicia. Es un problema grande de la humanidad, que no es únicamente con Ecuador. Es un problema de la humanidad, y este caso, como siempre decimos, es un pésimo precedente para los derechos humanos de todo el planeta. Insisto, se sigue imponiendo el derecho económico sobre los derechos humanos de las poblaciones y también ahora de la naturaleza. Muchas gracias.
Thanks a lot, Pablo, for your super important contribution on this denial to the access to justice for affected communities. I just would like to see if Humberto Piaguaje is already here. I think not yet. Okay, so otherwise we will pass to the next panelist, and we will dedicate a space specific for questions at the end of the webinar. So now we're going to reflect on the big exclusion and how ISDS marginalizes local communities and nature, building, of course, on the contribution of Pablo Fajardo. And we'll have two speakers. First of all, Alessandra Arcuri. She's a professor of inclusive global law and governance at the Department of International and European Union Law at the Erasmus University of Rotterdam, and her research focuses on international economic law and the relationship with human rights, and the relationship with human rights and environmental law. So besides teaching regularly at the Erasmus School of Law, she also taught courses in several universities in different countries. And then we will hear to Mike Niehoff, but I will introduce afterwards. So Alessandra, the floor is yours, and you have 6 minutes. Thanks a lot.
Thank you. Thanks, first of all, for inviting us. It's an honor to be with you and to share some of our insights on this system called investor-state dispute settlement. Will our slides be shared by the moderator? Yeah? Okay. So we were already introduced. This is a joint presentation by myself and Maike, who is both researcher at SOMO and writing a master thesis on the case of Chevron versus Ecuador. Next slide, please. So just a few words to introduce those of you who are not familiar with the system, how this works and why this is quite exceptional. This is a system that is created by treaties between two states that you can see in this slide. Normally, these are called bilateral investment treaties. And what is very special about this system is that it protects investors that goes to invest in another state. Now, if there is a dispute, if there is something going wrong between the investor and the state, the investors can immediately bring a challenge against the state. What we want to emphasize here that this is really special. Local communities are completely excluded by this system, and there is no other dispute settlement system in international law that gives such a strong rights to private actors. Next slide, please. Yeah, so What we want to tell, this is like a rigged game. Imagine a football match in which there is only one team that can score. This is what we have with ISDS. So the state can only act as a defendant. The investors has no or hardly any obligation, and there is no rule on exhaustion of domestic legal remedies. What does it mean? It means that an investor having a problem with the domestic state where it invests does not have to go to the legal courts in that country first. It can immediately go to a system of arbitration. Usually it's 3 arbitrators. Now, is it surprising? So you could see you could improve a system like a rigged game if you have a system where only one football team can score, but the game remains rigged. And we are not surprised of that because there are many studies that show how this system actually has a colonial origin, starting from the rules that have been developed for the Dutch East Indian companies until our days. In fact, one very recent study by Nicolas Perrone show how some of the drafter of these model conventions were linked to, for instance, Shell, and these treaties started to be drafted in the moment of decolonization. They were started to draft to tame decolonization, so to limit the power of the state. Next slide, please. We talk of a big exclusion because not only this regime is already in itself exceptional, giving only rights to investors and not to states, but also by the fact that there is no voice and no rights whatsoever for local communities or the environment. And here is the catch, here is the big problem. The state does not always represent the interests of local communities, of the general public. There is plenty of evidence in the literature that the state at times, especially when there are extractive industries, may collude with corporations. So there is evidence that the state may disregard the public interest in its conduct. Hence, having a system that completely excludes the local communities and environment is highly problematic. Next slide, please. Yes, so let me briefly go to the Chevron versus Ecuador, which already was explained very well by Pablo. I want to point to attention to just one aspect because we have very short time. So in this award, in this ruling, it was given a lot of attention to an agreement between Ecuador and Texaco Chevron to say, well, remedial damage will be given and have been given in 1995, and this is all fine. However, in the arbitration tribunal, nothing is said, and there is hardly any reflection on a couple of crucial issues, such as were the local communities sufficiently consulted when the settlement agreement was concluded? And the answer is no. Was the agreement fair? Now, arguably not. And here I just give a very quick example. Now, in a case of oil spills in the US, the famous Deepwater Horizon spills, there has been a settlement to pay $20 billion in penalties and damages, which is far higher than what has been paid and done in terms of remedies in Ecuador. And just as a matter of comparison, in the case of the Deepwater Horizon, 134 million gallons of oil have been spilled, whereas in the case of Ecuador, we are talking of 18.5 billion gallons. So it's like two completely different words. Finally, has the arbitration tribunal considered this question in any way? No. So, as Pablo said, this system is particularly problematic because in Chevron Ecuador is also a particular case because the arbitration tribunal ordered Ecuador, after there has been the case domestically, to not enforce its own judicial ruling, so the judicial ruling of its own court. And the question is, has the tribunal evaluated the implications of access to justice for the local communities? And the answer is not. They say that they can get justice, but the tribunal doesn't say how. After there has been a domestic trial, how can the local communities get justice if an international tribunal ordered the state of Ecuador not to enforce this judgment? And maybe in the Q&A we can discuss why this is quite difficult now. Finally, and now I pass the word to Maike, is there a possibility of appeal such arbitration award? And the answer is no, there is no appeal. The only things that can be done will be illustrated by Michael with this procedure of setting aside. I pass the word to you, Maike.
Yes, many thanks for giving me the floor, Alessandra. Could you please go to the next slide? Yes, many thanks. As already explained, there is no such thing as an appeal mechanism in ISDS, which is, I think, very problematic, given that this implies that awards that have a severe impact on local communities remain unremedied. Yet there is a limited possibility to set aside an award in front of the domestic courts where the arbitration was seated. So, for example, for the Chevron-Ecuador cases was The Hague, because the arbitration was seated there as well. This means that a set-aside request is subject to domestic arbitration legislation, and you can imagine that this law differs per jurisdiction. However, many jurisdictions have adopted the UNCITRAL model law, including its Article 34 on setting aside an award.
Maike, I'm sorry. Could you please speak a bit slower for the interpretation?
Yeah, sure. Sorry about that. Yes, so including Article 34 of the UNCITRAL model law, which includes some grounds under which an award may be set aside. This is an exhaustive list of grounds, which are mostly linked to issues of procedural law, and practice shows that domestic courts interpret these grounds very narrowly and apply them with restraint, and therefore show a high degree of deference towards the tribunal's findings. It has also been stressed multiple times that a set-aside mechanism may not function like an appeal mechanism in disguise. Set-asides are only concerned with procedural issues and may not reconsider the merits of the case, like in a regular appeal mechanism. Could you please go to the next slide? Yes, and I think the narrow scope of set-asides can be is illustrated quite nicely by the data we have on set-aside proceedings. And as you can see, in quite a lot of instances, a set-aside has been initiated. But when zooming in on these proceedings, we can see that an attempt to set aside an award is rarely successful. And in the vast majority of these cases, the award is being upheld by the domestic court, and only in a small part, the award is partially or fully set aside and based only on procedural grounds. Next slide, please. And I think that the Netherlands are no exception here too. The grounds under the Dutch Arbitration Act to set aside an award are similar to those found in the UNCITRAL model law, and it has been stressed multiple times, both by the legislator and by the Supreme Court, that Dutch courts may only intervene in exceptional cases, and that they should review the awards with a high degree of deference towards the tribunal findings, meaning that they should interpret the grounds for setting aside narrowly and should apply them with restraint. And again, set-aside proceedings are limited to procedural issues only. This means that legal incorrectness or factual incorrectness cannot be a reason for a judge to set aside this award. And I think when looking at these grounds, a remarkable one is the fact that an award might be set aside on a public policy violation. One would expect that a local court would conduct an in-depth analysis of the implications of an award on public policy if it is asked to review a decision on this ground. However, practice shows that judges interpret this ground again narrowly, and that this ground can only be established in case of a serious departure from fundamental and a mandatory principle of procedural law. For instance, when one of the disputing parties did not have the opportunity to be heard during the tribunal stage. And I think we can all agree on the fact that the Chevron-Ecuador arbitration has an undeniable and enormous impact on public policy, as it directly orders Ecuador to disregard its own juridical system, leading to a de facto annulment of an Ecuadorian court judgment. And at this moment in time, a local Dutch court is assessing the award's alleged violation of Ecuadorian public policy. Yet, in my opinion, public policy cannot be understood in a vacuum and requires a good understanding of the juridical system of Ecuador as well. So could you please go to the next slide? Yes, many thanks. And I think the fact that a Dutch local judge is entrusted with assessing this alleged violation presumes a superior position of the Dutch courts vis-à-vis those of the Ecuadorian system, which in my opinion gives rise to a neo-colonial logic. And I think that this very restrictive interpretation hollows out the core of public policy as a ground to set aside an award, which in turn begs the question of whether ISDS and its set-aside mechanisms are legitimate. So the question now is will a Dutch court, a local Dutch court, find the courage to break free from a neo-colonial legal imagination and thereby reconcile law with justice? So I thank you for your attention. I hope we have given you some food for further thought, and we'd love to see you back in the Q&A. Thanks.
Thanks a lot, Mike and Alessandra. We just remember that Mike Niehoff is intern at SOMO, and she's currently writing her master thesis on public participation in investor-state arbitration to complete her degree in international and European Union law. And her research is discussing the limited options for public participation in investor-state arbitration, as well as the narrow possibility for setting aside an arbitration award in domestic courts. And in particular, she's focusing on the Chevron Ecuador arbitration case. So we really look forward to reading your work after you finish your research, Mike. I will give the floor now to Humberto Piaguaje. Humberto, ¿estás ahí? Si puedes activar la cámara. Un momento, compañero. La cámara, si puedes prenderla, por favor. And I will be introducing Humberto. So it's really a honor to have Humberto here. He's an indigenous leader of the Siekopai nationality. He's also historic member of the Union of those affected by Chevron Texaco in Ecuador, UDAPT. And he's a plaintiff in the Chevron case in the United States and in Ecuador. And he has traveled to several countries to testify about the environmental, social, and cultural disaster caused by Chevron in different courts at the national and international forums. He was also coordinator of UDAPT. And yeah, I think it's really a key testimony, because he will be explaining to us the impacts of Chevron's pollution on indigenous peoples in the Ecuadorian Amazon, and he has the legitimacy also because he's talking to us from the Ecuadorian Amazon. So, Humberto, muchísimas gracias. Tienes 7 minutos.
Gracias, Mónica. Un cordial saludo a todos, hermanos, y a todos los aliados que defendemos por la vida y también por la naturaleza. Obviamente la Texaco y Chevron fue la primera empresa transnacional que llegó a Ecuador en la provincia de Sucumbíos, con el fin de explotar el petróleo y ganar el dinero para su empresa. Y operó durante más de 20 años en los territorios amazónicos de la nacionalidad Siona, Siekopai, Cofanes, Quichuas y Guarani. En ese lapso de tiempo de exploración y explotación, Texaco, hoy Chevron, destruyó y contaminó nuestro aire, selva, tierra y ríos, afectando gravemente la cultura, provocando la muerte de las vidas humanas inocentes, animales y el ecosistema. Pero lo más grave para los pueblos indígenas fue menoscabar los espíritus de los dueños de hábitat del mundo animal, de los peces, insectos, árboles, aire, aguas, fuego, etcétera, que para nuestros abuelos sabios fue indispensable, sobre todo la relación con este mundo de sobrenaturales, para mantener el equilibrio y dar la vida armónica que vive el hombre con la naturaleza. Hoy en día, mi pueblo Secoya, o Siekopai, que no pasa más de 700 habitantes, vive en peligro de extinción, ya que persiste mucha contaminación y otras amenazas como invasiones de territorios, influencias de otras culturas, enfermedades desconocidas, etc. Y todo eso es por la causa que atrajo al principio durante la explotación de la Texaco y Chevron. Y por esos problemas induce a los líderes buscar otros territorios que garantice la vida de nuestra futura generación, lo cual veo que es difícil obtener nuevos territorios. Chevron, antes Texaco, debe pagar cumpliendo la sentencia emitida por las Cortes Nacionales del Ecuador. Con ese dinero pensamos, al menos, restituir y reparar los daños ocasionados por la empresa en nuestros territorios. Ponemos énfasis y decimos que los pueblos indígenas no hemos vivido con el dinero, sino con el regalo que nos da nuestra madre naturaleza, porque en ella tenemos toda la riqueza. Es por eso pensamos los pueblos y nacionalidades indígenas que la empresa devuelva la naturaleza destruida por ellos mismos, aunque sea reparando algo, porque no va a ser una reparación en su totalidad como fue naturalmente, y que se pueda habitar dignamente en los territorios. Y esa podría ser el mejor pago que deberían hacer las grandes corporaciones en los pueblos que contaminan. Y hoy Chevron es lo que tiene que cumplir, es lo que esperamos nosotros. No es como ellos mencionan del fraude durante este proceso judicial, porque si hablamos de fraude, nosotros los indígenas no lo tenemos de dónde pagar y hacer fraude al abogado. Son ellos los que están haciendo el fraude. Entonces, miramos cómo es que tiene su defensa estructurada, su sistema de defensa más allá de todos los estados para su defensa y sobre todo su antojo a la economía. Entonces, por ejemplo, tenemos nosotros a los árbitros y las cortes que radican en Europa, que no saben sobre todo la realidad que ocurre en la Amazonía y dictan sentencia al interés de las empresas. Siempre nos han calificado que los indígenas hemos hecho el fraude pagando a los abogados. Mire todas estas situaciones que nos acusan a nosotros que solamente por buscar nuestra justicia, por la libertad y sobre todo sobrevivencia de nuestra futura generación y sobre todo en busca a los derechos humanos y también a la defensa a los derechos ambientales. Eso es lo que nosotros buscamos hoy en día. Por eso en este momento, en este día que declaramos Día Anti-Chevron, hablo y elevo sobre todo mis sentimientos como pueblo indígena y como nacionalidad Siekopai, para que todos ustedes que son aliados a esta lucha puedan escuchar y para poder defender lo que nos da sobre todo el regalo de la naturaleza. Y por último quiero decir que nuestra madre naturaleza hoy está en la angustia, sufre de las grandes enfermedades que corre por las arterias principales que son nuestros ríos amazónicos y del mundo, por la gran contaminación de petróleo, mercurios y otros elementos químicos. El aliento de nuestra madre es muy pobre, ya que desvanece con los mecheros del petróleo, químicos, nucleares, fábricas y combustiones provocadas por el hombre. El cuerpo que es la tierra está muy pobre en producción y en reproducción de los alimentos. Ya se termina la vida digna o el buen vivir de la naturaleza. Esta es la razón y la reacción de los espíritus de nuestra madre naturaleza con grandes tempestades, huracanes, terremotos, etcétera, que hoy en día escucho la famosa palabra del cambio climático. Ese daño del mundo es irreparable e irreversible. Y Chevron, que hizo daño intencionalmente en nuestro hábitat, debe de responder y no se debe quedar en la impunidad por su poder económico. Más bien debe empezar demostrando y asumiendo la responsabilidad y reparar esos daños ocasionados a los pueblos indígenas. Esa es mi palabra y sentimiento de los pueblos indígenas, que realmente hemos vivido por siglos milenariamente en nuestras selvas y en un lugar donde que en ningún momento hayan afectados, hemos vivido dignamente y muy ricos por la naturaleza, no por riqueza económica, sino por la riqueza natural que nosotros hemos tenido. Muchísimas gracias.
Muchas gracias, Humberto. So yes, after this so important participation, no, from the Ecuadorian Amazon, I think it is also important to stress the participation of UDAPT and Humberto, Pablo have been at the UN, also supporting the struggle for the UN binding treaty, no, in order to impede the fact that that type of cases happen again. We have also, bueno, during the interventions of Mike and Alessandra, we also got this reflection on the participation of the Dutch courts. But it's important to know that the ISDS cases and actually corporate impunity is not only affecting the global south, as we have seen with Ecuador, but is also affecting and increasingly northern countries. And that is specifically the case of the Netherlands that we're going to hear about now with our next speaker. So we will be hearing from Bart-Jaap on the political debate concerning ISDS in the Netherlands and Europe in particular concerning public interest cases such as the RWE climate litigation. Bart works as researcher at SOMO, and he specializes in the transnational governance of trade and investment and the impact on labor, environment, democracy, climate, and human rights. And he examines in particular how trade and investment agreements enhance and protect transnational capital flows and what the implications are for the equitable and sustainable economic development. So, Bart, the floor is yours. You have 6 minutes. Thank you.
Thank you very much, Monica, for the kind introduction. And many thanks for the opportunity to share a few thoughts about another ISDS case that involves public interest regulations in relation to the struggle against climate change. If I could please have the slide back up, yes. Thank you. Yeah, thank you very much. Well, I actually have to talk about the 2 cases, like in plural, because it's now 2 German companies that are suing the Netherlands for its decision to ban coal-fired power generation from 2030. If I could have the next slide, please. Thank you. As we heard before in the previous presentations, international investment treaties grant foreign investors strong protection against government actions that may undermine their business activities and that extend beyond what would be applied in many domestic legal systems. And these include, among other things, broad and vague standards like the fair and equitable treatment, which is often interpreted as protecting the investors' legitimate expectations, but also protection against indirect expropriation, which can cover a wide range of regulatory measures that affect the business and its profit model. And investment treaties generally focus very narrowly on the promotion and protection of investment, and therefore they offer very little room for public interests to be represented or to be reflected in the proceedings. Now, in case of a breach of any of these standards, sorry, could you go back to, yeah. The governments are required to pay a compensation for the damages incurred by the disputed measure. And generally, states are directed to pay compensation at fair market value of the asset in case of an expropriation. But this is generally not further defined, nor what compensation to pay in case of, for example, a breach of the fair and equitable treatment standard. And there is much inconsistency and much unpredictability when it comes to damages and compensation. And tribunals have wide discretionary powers to choose what methods to use. And tribunals are increasingly basing compensation on projected future income during the investment's entire life cycle, which also may help explain why we are witnessing a significant increase in the amount of compensation awarded by tribunals in recent years. And there is, of course, a high degree of uncertainty here about the future income and value of assets that may become stranded, such as fossil fuel assets, which makes forward-looking approaches to determine a fair market value rather speculative. Could we go to the next slide, please? Thank you. So in 2019, the Dutch Parliament adopted a law that prohibits coal-fired power generation from 2030. And this law provides for compensation only in the form of a 10-year transition period, which, according to the government, would allow the owners of the coal plants to shift to alternative forms of energy production. And both RWE and Uniper opened brand new coal-fired power plants in 2015 and 2016. And both argue that the law forms an expropriation because they will not be able to run the plants profitably after 2030, at least not without major subsidies to switch to alternative fuels for energy production. And they claim that compensation is required. They also argue that the law violates certain expectations that they had when deciding to construct the plant 15 years ago. And they claim that those expectations were partly generated by the Dutch government. And the amounts of compensations are actually quite staggering. So RWE is claiming 1.4 billion euros in compensation. And Uniper has referred earlier to damages ranging between 850 million euros and 1 billion. Next slide, please. Thank you. So the first question that raises is, of course, how much worth these plants actually are. And we at SOMO have recently published a study on the value and the profitability of the Dutch coal plants together with international energy think tanks, AIFA and Ember. And we found that the plants have been already largely depreciated. And this is not due to the Dutch coal prohibition law, but it's also largely due to the worsening market conditions for coal, which has been driven by increasing carbon prices and competition from renewable energy sources. The plants have been loss-making for the past 2 years, and we expect that they will no longer be economically viable by 2024 at latest. This strongly suggests that the expectation to make profits with coal-fired power production past 2030 is rather misguided. Next slide, please. Thank you. A second related question is how realistic it is for an energy company to open a coal-fired power plant in 2015, in 2015 and 16 and expect to be able to run it for the full lifespan of 40 years. Just as the tobacco industry can only expect more stringent public health measures aimed at discouraging smoking, I would argue here that fossil fuel companies could only expect more stringent climate measures aimed at reducing CO2 emissions. And these expectations were clearly spelled out by the Dutch government at the time when the permits were issued and in the years after that. So the construction of the plants was highly controversial. There was a lot of opposition in parliament and many environmental groups protested against it. And the government strongly communicated that it expected the plants to undertake efforts to reduce emissions. And the owners of the plants also promised to apply large-scale carbon capture and storage techniques to mitigate additional emissions that they would produce. And actually, these expectations were the reason for the government to give the green light for the construction of the power plants. And despite millions of subsidies, they never successfully applied these techniques. So that new, sorry, one second. I'm very sorry for this.
No problem.
When you have to work at home. So yeah, actually the energy companies did not fulfill their promises to reduce or to undertake efforts to reduce emissions. And also at the same time, there were some recent developments that were really focusing on more stringent climate measures. So in 2015, we had a landmark court case in the Netherlands whereby the Dutch state is ordered to reduce emissions with 25% by the year of 2020. And it's also in the same year when the Netherlands signed the Paris Climate Agreement, and that the Dutch parliament started to call for a coal phase out altogether, which became part of the program of the newly installed government in 2017. So altogether, if we could have the next slide, the final slide. Yeah, thank you. So what we make of this is that both companies, they appear to have made rather poor investment decisions, and they are now trying to shift the risks and the costs of their unprofitable assets to Dutch taxpayers. They have actively lobbied the government and the parliament to withdraw or amend the law to provide for compensation, including by threatening and using the Energy Charter Treaty. And these cases potentially set dangerous precedents by exposing governments to substantial and unreasonable compensation claims. And other governments considering similar coal phase-out strategies may feel compelled to drop or to water down regulations or to provide very generous compensations under the shadow of ISDS, as we have seen in the case of the German coal phase-out. So to wrap up, there is an increased need to look at these types of investment treaties and arbitration mechanisms when we talk about the energy transition. And as governments are only taking more steps to reduce reliance on fossil fuels to reach their climate objectives, we can only expect more of these compensation claims in the nearby future, as such measures will inevitably interfere with the business model of the fossil fuel industry. So there is a strong need for governments to work towards a fundamental reform of the investment treaty regime. And when such efforts don't deliver, really consider to terminate these treaties or to withdraw from the Energy Charter Treaty, for example, to restore the much needed policy space to regulate in the public interest and to promote a just and fair low carbon energy transition. Thank you very much for your attention, and I'm looking forward to answering any questions.
Thanks a lot, Bart. I think you have really touched the core issue of corporate impunity, and perhaps it's also important to tell that there is a campaign going on in order to ask the states that to withdraw of the Energy Charter Treaty, identified as one of the core treaties that is really challenging any policy for against climate change. So thanks a lot. We're going to go to our last panelist, that is precisely, I think, linking a lot with the last intervention, the last words of Bart. So we welcome Christian Rousseau. Christian will be discussing on shareholders, how shareholders can question corporate power and how we can use the voting rights and AGM speeches. And so Christian is a journalist and a writer, as well as board member of okay, I will try to say it, Dachverband der kritischen Aktionärinnen und Aktionäre. He's also editor of the Latinamerika Nachrichten, that's news on Latin America. And he's active at the Berlin Research and Documentation Center, Chile-Lateinamerika, FDCL, as well as the Initiative gegen Strömung and the Network Cobra, the Cooperation Brazilian. And he also regularly intervenes on shareholders' meetings of basically German corporations. So Christian, the floor is yours. You have 7 minutes, and thanks a lot for joining.
Yeah, thank you so much. Can you hear me? Yeah. Thank you so much for giving me the opportunity to speak here. Well, we as, in English, it would be ethical shareholders. In German, we say kritische Aktionäre, because for us important is the word critique, because we take the critique to the inner public sphere of the corporations, which is their annual general meeting. And for this reason, we buy as an association 1 share of each of these big, huge corporations. And so we have the right to vote, which is a minor vote because we're not the majority, but we have the right to speak for up to 10 minutes on their annual general meetings. And normally in Germany, on the big corporations, they do participate between 5 and maybe 6,000, 8,000 smaller shareholders in the venue. So on the cases Chevron, Uniper, and RWE, we went regularly to their shareholder meetings. In 2019, I went to the AGM, the annual general meeting of Deutsche Bank, to ask them why do they still have assets of Chevron. And in 2021, we as ethical shareholders, we only could put in questions via email because of the Corona pandemic. There hadn't been a live meeting, but we asked them about the RWE and Uniper, about their lawsuit based on the Energy Charter Treaty against the Netherlands. And the answer of the corporations RWE and Uniper basically was that this investor to state dispute settlement was launched against the Netherlands because we as a corporation were obliged to do so. Because if we hadn't do that, that would be against the shareholders' interest. So we will try to see what are the shareholder interests. Could we please start the slide? Thank you so much. Yeah, so you can go to the next slide, please. Yeah, there you see the top 10 owners of Chevron Corporation and the mutual funds holding Chevron. Just to give you an idea, the Vanguard Group, BlackRock is there, Berkshire, Norges, etc. There are several ones. Can we go please on? Yeah, here you have a vision about again, there's BlackRock, and there are a few private shareholders, and but mostly we see it's 80% other institutional shareholders, mostly from Germany, US, Canada, UK, etc. Can we please go on to the next slide? There's Uniper. You see Fortum, which is from Finlandia, owns most part, but still there are many shares from Germany because originally it was a German corporation, Uniper. So can we go on, please? Yeah, so we see that we have institutional holdings, corporations, which have shares of the most of the corporations, and this causes some kind of structural asymmetries. So as small shareholders, they're a minority, and so by votes, it's very, very difficult to change anything in these corporations. For example, even if you would try to launch a vote or try to discharge the members of the board, of the executive directors and supervisory board, with these asymmetries, it's not possible. You may remember that 2 years ago, it was Bayer where the CEO was discharged, but this was a really exceptional case, but even though he's still in his function as a CEO. But there are more and more initiatives around the world where ethical investors, churches, funds, etc., organize themselves with others to launch contrary votes, but this is still a vast minority. Can we please go on to the next slide? So major shareholders such as BlackRock and Vanguard or Allianz Asset Management, they manage a large part of the money of pension funds around the world. And most members often do not know how their stock rights are managed with regard to the environment and climate protection. Recently, there have been a TV broadcast here in Germany, an example about RWE. There's a family which lives in the Rhineland. I don't know how many of you are familiar with the Rhineland area, which is the biggest lignite mining, brown coal. And it's used for electricity and until 2038. And there was one, in this broadcasting was one family, they will be forcibly removed. They don't want to, they want to stay there. And they have, with Allianz, made a private pension fund. And when they bought this private pension fund, there had been the guarantee there's no coal inside. And then some journalists went after this and discovered that, it was really difficult to discover that, but they finally managed it, that in this portfolio where obviously there would be no coal inside, instead there was RWE inside. So even if ethical, ecological or social investors would prefer to invest correctly, there's not enough transparency. Can we please go on to the next slide? So there are several strategies and tactics, among others. I mean, one of these divestment, no, because it has some years that there's huge campaigns by a lot of organizations, NGOs, to make a co-divestment. For example, the insurance companies are more and more divesting. They're still in, but it's in process, which is ongoing. Or you might remember of the divestment campaigns against nuclear weapons, for example, or arms, etc. We need campaigning, but at the same time, we need to use the media and put pressure on politics to change the legislation. And in the annual general meetings, we can try to name and shame, bring our critique there and name and shame the CEOs and try to convince more and more minor shareholders to act together with us. Can we please have the next slide? Yeah, so the main point of what we are doing is that we enter the corporation's own public sphere and demand to be listened. It's important to know that there are different national legislations across Europe for shareholders' rights. In Germany, for example, normally we have ideally, even with one share, you can speak up to 10 minutes and the directory board has to answer. More or less, they always try to find a way to avoid answering, or for example, especially the insurance companies, they love to answer that on this specific case, they cannot, because of reasons of confidentiality, they cannot answer. So what we do is trying to name and shame the directory board while trying to convince the small shareholders and medias. That means that we do not always make their friends. For example, I guess it was 3 years ago that another shareholder screamed at us and called us lefty eco pseudo shareholders. I personally understand that this wasn't a critique, but the next point the people are the other shareholders who were thinking only about profit is, it has been some month ago that a shareholder publicly at an annual general meeting asked that we, the pseudo shareholders, should be expropriated. So we see that these the shareholders have different understandings of expropriation. When it's about their industrial fabrics in the Netherlands, they are totally against any kind of expropriation. But when we take the critique to the shareholder meetings, then they're easily demanding that we should lose our one share. So while going to the shareholder meetings, there's the hope that maybe next year some minor small shareholders pass the voting and speaking rights at the AGM for us activists. Can we pass the next slide, whether there is one? Yeah, so it's important to know that these several and multiple strategies brings only gradual changes in small steps. We're not doing a revolution with that. Phasing out of nuclear weapon, arms industry, coal, then gas and oil. But everything, this is an ongoing and very, very slow process, giving the shareholders powers and their interests. And sometimes when the public opinion, media, and even politics got into too, it might be possible to win some minor cases. For example, I would just remind, Volkswagen had been collaborated with the military dictatorship in Brazil. We brought the case to the AGM, and during years we worked together with the workers, former workers of Volkswagen in Brazil, and finally they got in some money in indemnization. Insurance companies are more and more phasing out coal. The free, prior, and informed consent of indigenous communities, how it is defined in the ILO 169 for the rights of indigenous people. The Allianz did incorporate it after years of our critique. They did incorporate it in their environmental, social, and governance policy. Heckler & Koch last year declared publicly, after we asked them, they declared on their AGM that they are not any longer exporting arms to Brazil since Jair Bolsonaro is the right-wing president of Brazil. So confronting the corporate power in AGMs is one tool among many others, and it makes only sense when combined with social movements, civil society, struggles, etc., and then when it tries to get attention in the media. And just one last point, all these measures try to that at least we be able to change somehow the legislation. Because the problem is not the only case, the problem is in the system. No? We need some legislation that clearly puts ecology and human rights before shareholders' profits. And just to give you some hope, because we identify as well the justice system, for example, as the ISDS justice system as a wrong system. But even in the justice, there are always some small possibilities. I just would like to remind you on the case on RWE, the German NGO German Watch, together with a local farmer from Peru, Saul Luciano Luya. He's living in the Andes, and some 100 meters up from his house, there is a glacier, and this glacier is melting. And they, together with German Watch, they launched a lawsuit here in Germany because of the historical responsibility of RWE for climate crisis. And for all our surprises, 2 years ago, the judges here in Germany accepted this lawsuit, which is still ongoing. So we still have some hope that something would gradually help and go on. But it's always important to work together with social movements, civil society, etc. I would think this is no other slide, or is there? No, I think so. Yeah, thank you very much for the opportunity, and maybe we could talk together in the question answer. Thank you so much.
So thanks a lot to Christian and to all the panelists. We are now in the last part of our webinar, and we did receive some questions from you. I will read them, and I will ask our panelists to volunteer for answering to them. At least 3 are focused to Humberto and Pablo, but the other ones are quite open. So first of all, a question is, what happens if a government just refuses the ISDS claims, and has that been happening? Secondly, who the Dutch judges are? I will just, give 1 second. Who the Dutch judges are, and what is their expertise, and how are they selected? 3, can you say something more concerning the compatibility of the RWE arbitration with the intra-European laws? 4, this question is for Humberto. How did you feel when you learned about the decision of the Dutch justice without even knowing the affected voices and ignoring the affected communities' voices? How did you receive those news? For Pablo, also, how did you receive the information of the? How do you receive the information of the arbitration cases? And I'm sorry, I'm translating to English, so I'm just trying to find my words. How do you get the information from the arbitration tribunals? And for Pablo, finally, also, could you just tell us, how did you try to get the sentence be executed in other countries, for example, Argentina, Brazil, Canada, no? And why you didn't succeed in that? What was the main obstacle for that? So I will ask our panelists to answer, if possible, to those questions, and we'll have like 10 minutes maximum, and finally we'll have the last word of panelists. So who would like to start?
Maybe I can start with the first question very quickly. I partly addressed on the chat, but very quickly, basically when a state ratify a treaty, these bilateral investment treaties, they consent to this investment arbitration system. Virtually all bids, we have more than 3,000 in the world now, have this system. Another question could be, can you refuse to enforce? Once the award has been rendered, can you refuse to enforce? And that's quite difficult, because without entering into the technicalities, but basically what's very exceptional about this system is that you can enforce in all the member states that are a member of another convention. So we are talking of 164 member states, meaning that me as an investor, if I am awarded damage, now with Ecuador, there is a very special case because the award was obliging Ecuador not to enforce its own domestic ruling, but generally we talk of damages, and so investors can go in many jurisdictions. So you have all the, you can, for instance, let's say I'm an investor that has won an award against the Netherlands. I can try to enforce it also in the US, in Russia, and so on and so forth. So basically, it doesn't mean that you can always enforce as an investor, but it's very likely you can enforce. In terms of international law, it's one of the most powerful enforcement mechanisms. It's not 100%. For instance, Russia is a country that can manage well not to enforce an award, but other smaller countries may have much more difficulties. And I think then Pablo might touch upon why it might also be very difficult for Ecuador to say, okay, if you want to disregard the award, what happens? Because if you want to have the people to enforce their ruling, you need to have the assets of Chevron. Where are these assets, and who is going to enforce the award when the international award we are talking about has also obliging Ecuador not to let other countries to enforce this ruling. So it's very complicated, but very shortly, the answer is very, very difficult to get away with it.
Thanks a lot, Alessandra. Perhaps as you mentioned that we can ask to Pablo to answer, to address that question that was for you, no, regarding all the path towards trying to get the award, like, bueno, the sentence executed, no, enforced. Adelante, Pablo.
Gracias, Mónica. A ver, dos preguntas netamente ahí. Primero, ¿cómo nos informamos sobre la información de los tribunales de arbitraje? Es una cuestión bien compleja, porque infortunadamente el sistema mismo, entre comillas, garantiza la confidencialidad de los litigios. Y claro, la información que la maneja el Estado, en este caso con Chevron, la cual la población afectada de la Amazonía ecuatoriana, pese a que son sus derechos que están en juego, conoce muy poco. Y hay una cuestión ahí también de violación de derechos, porque nuestra Constitución garantiza el derecho al acceso a la información de forma veraz y adecuada y óptima y oportuna, ¿sí? Pero en este caso el Estado no informa, la empresa no informa, y nos enteramos ya cuando existen las decisiones de los laudos arbitrales. Es una cuestión, digo, que nos dejen una completa indefensión en estos procesos. La segunda pregunta que me planteaban de lo que estamos haciendo, también la ley franquea los procedimientos de exequatur o de homologación de sentencia, que es un proceso directamente jurídico en la cual la sentencia que es emitida en un estado soberano tiene que hacerse la validación en otro estado, y ese proceso se llama exequatur, ¿sí? Así lo intentamos en Argentina, Brasil y Canadá. Y obviamente en eso, más que todo en Canadá, el caso estaba avanzando, diría, bastante bien. Teníamos muchas posibilidades de éxito en la Corte Suprema de Canadá. Todo iba súper bien hasta que llegó una carta del Procurador General del Estado ecuatoriano, del gobierno ecuatoriano, en la cual le dice a los jueces canadienses, o le insinúa, por ser más exacto, que no admitan el trámite de exequatur planteado por los afectados de la Amazonía ecuatoriana en vista que había un laudo arbitral. Y que ese laudo le decía al Estado que debía anularlo. Entonces, obviamente, como digo, no pueden anularlo. La sentencia nuestra es definitiva y está en firme. pero el Estado busca mecanismos junto con Chevron y también quizás con jueces, en este caso holandeses, para tratar de obstruir y de impedir que podamos validar nuestra sentencia en otras jurisdicciones. Hoy nosotros tenemos preparadas 2 acciones más de exequatur, que esperamos plantearla pronto, pero obviamente, bajo este sistema que tenemos en el mundo, sí la repensamos mucho en qué momento la planteamos y dónde la planteamos, porque necesitamos garantías de acceso a la justicia. Pero como están las cosas ahora, con el sistema de arbitraje y SDS, con la sentencia del sistema judicial doméstico holandés, que violenta nuestros derechos, nos deja en una seria desventaja frente a esas acciones de exequatur.
Gracias, Pablo. So perhaps the other panelists would like to answer one of the questions that were copied in our chat as panelists. Someone would like to jump in?
Yeah, I can go. I saw the question on the Dutch judges, who they are and how they are elected. Well, the names of the judges are just in the judgment. You can find them online. I don't know on top of my head. But generally, these are judges that are specialized in civil procedural law, in Dutch civil procedural law. So they also do a bunch of other cases. So they're not specialists, as already taught before by Pablo. Yeah, they do have some experience with these proceedings. But also research has shown that, as I also mentioned before, is that Dutch local courts and also in general local courts are hesitant to reverse findings by tribunals. And the fact as well that these judges are literally far removed from the subject matter of the dispute. So it's questionable whether they are aware of the effect they have on local communities, for example, in the Chevron-Ecuador case. And another, this is different from the tribunal stage as well, given that in the tribunal stage, the arbiters are chosen by the parties. Each party selects one arbiter, the other one selects one, and then the third one is generally selected by the first 2 arbiters. So there they are selected, whereas in the set-aside proceedings, they are appointed for life and are just regular procedural law judges.
Thanks a lot, Maike.
Sure.
Perhaps Bart, you would like to jump in, or Christian?
Yeah, I can touch upon the 4th question with regard to the compatibility of the RWE case with EU law. It's actually a very good question, a very relevant question, because in 2018, the European Court of Justice actually ruled that disputes between companies from within the European Union against another member state of the European Union were actually found incompatible with EU law. And as a result of that, EU member states terminated their intra-EU investment treaties. But this 2018 ruling does not apply yet to the Energy Charter Treaty. But actually the European Court of Justice is now preparing a ruling also on the compatibility of the Energy Charter Treaty with EU law. And if the judges follow the reasoning as they have done in the previous case, there is a reasonable chance that they find also the Energy Charter Treaty incompatible with EU law. And actually the Dutch government is really bringing this argument in the case as a defense. So the Dutch state has gone to a German court recently to have the legality and the validity of the case checked by a German court. So we'll have to see what comes out of this. I think, but it's also important to keep in mind that even if there is a ruling from the European Court of Justice, it does not necessarily mean that the arbitrators in the tribunal will follow such a ruling, because previously they have ignored the 2018 ruling. So there is, they're not bound by EU law, these arbitrators. So it's also very problematic.
Thanks a lot, Bart. Yes, please go ahead, Christian, and then we'll have a question for Humberto. Go ahead, Christian.
Yeah, thank you so much. I would like to answer the question three. When you have ratified a bilateral investment treaty, you as a state typically give your consent to ISDS. You cannot refuse the claim. I would say it's even worse. If we looked at the case of Brazil, they signed 14 bilateral investment treaties, never ratified a single one. But in 2011, at the hydroelectric power Jirau at the Rio Madeira, there have been riots of the workers because they were treated bad, didn't receive enough money, etc. And they destroyed the whole construction area nearly. So there had been damages in the millions. And then the construction firms wanted from the insurance firms the money back. But the insurance firm took out the contract and said, well, if there is some dispute, we go to the Arias court in London, something which is absolutely illegal on Brazilian law. But and there had been a Brazilian judge who ordered, if you go to Arias court in London, then you will, as an insurance company, you would have to pay so much money every day. And there has an international law decision of Arias court that this court decision in Brazil is not valid. If they maintain it, then the state would have to pay some more and more money. So at least, even if it's illegal, Brazil never ratified, and it was an inner dispute in Brazil between the construction companies and the insurance companies. The trial went to the tribunal at Arias in London. So it's always the private law which beats the state laws, and this is terrible.
Thanks a lot, Christian, especially if we know the so severe impacts that those companies have caused in the Amazon, the Brazilian Amazon. No, that is really amazing. So I would like to ask to Humberto also regarding how is the reality now in the Amazon, because this trial with the with Chevron and before Texaco is has like more than 20 years, almost 30 years of existence, but are there damages still now? How are you living today still the impacts of the corporation, even if she has left the country? Humberto, adelante.
Sí, en relación a la primera pregunta, ¿cómo hemos sentido, sobre todo cuando una corte holandesa haya dado la sentencia? Nosotros hemos pensado primeramente que cómo controlan o cómo es que saben la realidad sobre todo lo que existe en la Amazonía. Yo creo que esto para nosotros fue, es decir, no era una justicia realmente con el fin de poder apoyar o sobre todo dar un ejemplo de la justicia de estas empresas, ¿no? Entonces, e incluso los jueces tal vez son de las mismas, ¿no? Entonces, no hay otra línea como pueblos o nacionalidad indígena que pensemos que ellos van a hacer justicia propiamente a los que están afectados. Entonces, más bien, nosotros seguimos siendo afectados tanto de la justicia, que no ha llegado aún la justicia realmente a los pueblos indígenas, y mucho más. La última pregunta que hace ahora Mónica, el impacto que nos ha causado irreversiblemente a los pueblos indígenas es la enfermedad como es el cáncer. Todo este tiempo, como más de 20 años, que operó desde el año 1967, ya cuando empezó a operar con las actividades hidrocarburíferas en la Amazonía, ha contaminado nuestros ríos, que son principalmente fuentes de aguas que nosotros consumimos, como el río Aguarico, el río Chuchufindi, el río Eno y todas las demás riachuelos que pasan por nuestras comunidades. Estas son las afectaciones que nos ha causado gravemente, y las consecuencias son estas enfermedades como el cáncer. Muchos miembros de las comunidades, tanto mujeres y hombres, últimamente están falleciendo. Hace unos 20 días atrás falleció una señora con cáncer en el útero, una señora de 34 años. Y cada vez más, muchas señoras están enfermas de las comunidades, pero nunca lo hacemos ver ante un médico por falta de recursos económicos. Yo creo que este pueblo tan pequeño, tantas cosas que ha impactado a su hábitat natural, también nos impacta y nos duele a nosotros, sobre todo lo que muere en nuestras familias, sobre todo las vidas humanas, quienes han querido vivir dignamente en su hábitat natural, hoy solamente encontramos la muerte. Esa es la realidad, el impacto tan grande que nosotros los pueblos y nacionalidades sufrimos desde nuestro sentir cultural y desde nuestro sentir dignamente en la vida hábitat natural que hoy hemos sido más bien destruidos y sigue destruyendo nuestra hábitat natural. Eso es lo que podría decir un sentimiento de la respuesta desde mi sentimiento interno de como Siekopai.
Thanks a lot, Humberto. I think this is really the most important part, no? To see, also to show you, no, that that here you're not alone. You're not alone, no. I mean, we are all here to struggle against this impunity and to find a way, you know, that it doesn't repeat in other places. So first of all, to show to you this all our solidarity and strength, no. And this, brings me to the very last word I would like to ask to all panelists. I would like to give you 1 minute to answer to a question that I think would be important, and after the webinar we can still reflect on that, and that will be which strategies can be used to fight against the ISDS and in general concerning those two cases, and how can we organize and cooperate. So yeah, I would like to hear from you if possible during maximum 1 minute, and then we will do the closure. So perhaps we could start with Pablo, if you would like to.
Claro, Mónica, con mucho gusto. Sí. Yo creo que dos cosas cortas. Primero, tenemos que dejar de pensar con esa mente colonizadora, con esa mente de que es una guerra, una batalla entre países del sur contra países del norte, de ricos contra pobres. Es un problema global y es un problema de derechos humanos. Los países y las poblaciones del norte debemos trabajar juntos a los pueblos del sur. Hay que entender que las corporaciones a veces hacen más daño en el sur, pero obviamente se originan en el norte. Sus beneficios van directamente allí y la población del norte debe entender que son parte del problema y también debe ser parte de la solución al problema. Tenemos que trabajar mucho más en eso. O sea, ese tejido de solidaridad hay que incrementarlo y mejorarlo. No podemos dejar que estos crímenes como el de Chevron y otros queden impunes. La respuesta está en nosotros, no está en los gobiernos, está en nosotros.
Thanks a lot, Pablo. Perhaps we could ask to Alessandra to continue.
Yes, thanks. Well, it's a huge question. I think it seems that everybody was very puzzled. How is it possible that the legal system allows these horrible things? And in fact, this is our point of departure, that sometimes things are lawful but awful. So what is the strategy to fight this? Of course, as an educator, I think we should work at that level by decolonizing our curricula, meaning recognizing the degree of colonization or colonial thinking that still shape much of our legal institutions, to change them. And second, I think there can be act of legal mobilization by which you try to use the instrument that we have in a way that subvert this colonial thinking. It needs a lot of imagination, but it's not impossible. So I think with widespread solidarity also among the lawyers that started this process of decolonization, maybe we can move somewhere together. So, and thanks to all of you for the work you are doing in this process.
Thank you, Alessandra. We will take note of those contributions. Maike, would you like to continue?
Yes, sure. Of course, I only have a limited experience with these cases yet, since I'm a master's student. But I believe that for me, the finding I have found so far is that for me, the most important thing is that you put the investor rights at par with the rights of the affected communities, and that you give the same rights to them because they are greatly affected by them. I don't see directly how, maybe open up the process, the system for them to participate directly rather than indirectly via a state. I think that is the most challenging thing here, but would also be the most effective one. So yeah, and again, I also want to thank all of you for organizing this, and it was an honor to be here. Thank you.
Thank you a lot, Maike. Perhaps we could go to Christian or Bart for a final intervention.
Yeah, thank you so much. I would like to remind on the annual general meeting of RWE, the CEO answered they were forced, they were obliged to launch this lawsuit against the Netherlands, whether they liked it or not, because if they wouldn't have done it, the shareholders could have sued and processed them. I would say the only way we can change this is we have to work, and it's a process of many decades, probably many years, we have to work to change the legislation so that human rights and ecology, nature, the rights of nature are more valued than property. I mean, this is a problem and I don't have the answers how we go there, but we have to fight. That's the only thing I can say. Thank you so much.
Thanks a lot. Perhaps we can go to Bart. Would you like to give a final word, Bart? Perhaps Humberto, would like to give a final word?
Bueno, yo solo quiero agradecer, más bien no tengo ninguna sugerencia, pero sí admiro, igual, aunque estén viviendo muchas personas fuera de la situación realmente de los lugares afectados, el apoyo que nos brindan mucho más a nosotros. Entonces eso nos fortalece mucho más y seguir luchando sobre todo el derecho a la vida, el derecho a la naturaleza. Eso nos faculta, eso es el compromiso de nosotros. Y mucho más estamos nosotros convencidos, aunque ese apoyo llegue muy poco, pero internamente estamos defendiendo nuestros territorios, nuestras aguas, y eso es fundamental. Entonces no sentimos nosotros solamente la lucha, sea desde aquí nada más, solo el Ecuador o a veces de los pueblos indígenas, sino más bien esta lucha, pensar más allá, y es como o sea, no tiene fronteras, como siempre lo he dicho. Nuestra lucha igual tiene que sobrepasar esta lucha de todos para que las empresas puedan concientizar y mejorar sobre todo sus actividades. Y la justicia, los conocedores de la justicia, por favor, que tomen mucho en cuenta que el derecho de los pueblos indígenas o el derecho de la vida, el derecho humano que solamente no se escrita en las leyes y que nada tienen que cumplirlas, sino más bien que sean efectivas, sean legalmente cumplidas. Y eso es lo que nos hace mucha falta. A veces solamente escrito, pero es una letra muerta. Es lo que sugiero y trabajemos en ese sentido. Muchísimas gracias a todos ustedes y gracias por este día anti-Chevron.
Thanks a lot, Humberto. I think this is a very important closure, perhaps important to remind that in this Global Day of Action, there were other initiatives around, some webinars also before, touching different continents. So that shows also there is a huge support worldwide to the UDAPT struggle, which is also our struggle, as Pablo has said, this need of international solidarity, because it's also our problem. It's not the Amazonian problem, it's also our problem. I just would like to also remind how this ISD system really is a challenge for democracy. No? And I think this is a key point that every policymaker should take into account in order to challenge and to, of course, exit of those agreements or to avoid signing new agreements. I would just remind that the next agreement that the European Union is going to sign with renew with Mexico will be the first time that a Latin American country signs an agreement that includes the investment protection chapter, which is exactly to allow this type of cases again. And we will be having a webinar very soon. I pasted in the chat information about that, meaning that there are several waves of those agreements that we really need to analyze together and confront together. No, I will also paste in the chat for everybody the link to the Global Campaign Effort, where SOMO and several of the organizers here, organizations are part of. That's the global campaign that is really intending also to build a UN binding treaty that puts this human rights system above, no, and that reverse the asymmetry that we have treated just here. This asymmetry between the international trade and investment regime that currently is above the human rights. No. So I would like to thank to everybody, first of all, to the interpreters for the fantastic work, also to Abraham for the hosting of the technical hosting, etc. Of course, to Leticia, to Leti, to Susan for the preparation, and to all the people involved in this preparation, and to our panelists. Thanks again. And I remind you that the recording of this webinar will be at the Water Channel TV, hopefully. And yeah, please take care and have a nice afternoon, end of the day. And we keep on the struggle. Adiós, compañeras, compañeros. Gracias.